Welcome everyone to Benefits Compliance Considerations for Remote Employees. Thank you all so much for joining us. The Benefits Compliance team will be answering the questions you send through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we are unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We will be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday you receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At this time, I'll hand it over to Kelly Ackman, Vice President of Benefits Compliance at NFP, and Yoko Yoon, Vice President of Benefits Compliance at NFP. Kelly, the floor is yours.
All right. Thank you, Amber, and welcome everyone to our first edition of Get Wise Wednesday of 2025. Thank you all for taking time out of your busy schedules. Hopefully for a lot of you, if you have January renewals, things have calmed down a little bit. But we appreciate you taking time to listen to this topic. I think it's really important because I think as many of us, myself included, who are sitting in cold climates right now, sometimes dreaming of warmer places to live. And I think that's been happening over, the last 5 years or so with more employees considering going to other climates, usually warm ones. And so I think it's really important that we are talking about, how do these remote employees impact your employer benefit plans? So again, I'm Kelly Eckman and Yoko Yoon is joining me, and we're going to talk through, things that employers need to be thinking about if you currently have remote employees or if you are thinking of allowing some remote employees in the future. Next slide, please. We always have this reminder here. Again, what we're talking about today, this is just general guidance. We are not giving tax advice or legal advice. We will talk about some of that in here later. If you do have questions that are legal in nature, please take those to your own legal counsel. We cannot serve as legal counsel for our clients. The information we're talking about today, it is current as of today. In the benefits world, things are always subject to change quickly sometimes, but everything should be current as of today. Next, okay, thank you. So our agenda, so we're just going to kind of look at, we're going to start with, topics that are outside of scope. Not a great way to start, but just kind of looking at, what are things that we're not going to be able to talk through today. And then we're going to give an overview of, who are remote workers? Why is this information important for you to hear today? We're going to take a look at state insurance laws. So what do you really need to be thinking about if you do have employees that are in other states? We're going to take a dive into, federal FMLA and then also states that have their own specific leave laws and what that means for your employees. And then we're going to look at state individual mandate requirements. So again, we think about the ACA and the employer mandate reporting on 1095s. There are states that have their own reporting requirements as well. And then we'll have a list of key takeaways. So some things to think about after this webinar. Okay, so I'm going to start us off with, again, what are these topics that are out of scope for what we're going to discuss today? And so again, and the reason why I sort of like to start with this is just because when we're talking about remote employees, it goes so much further than just benefits, right? So it's going to go to a lot of state laws, tax laws, wage and hour laws. And so those are some things that we're not going to talk through. So again, state tax law, I said payroll, wage withholding requirements. Those are really important topics, especially if you only have one or two employees that are located in states outside of your home state. So you're probably very familiar with state tax law or wage and withholding laws in your particular states, maybe where you have, brick and mortar locations, but you may not be up on those same laws in California if you don't have a presence there. Like I said, there's also a lot of HR and employment law policies, making sure that your current policies that may apply more to your employees who actually go to a physical office, making sure that those are written so that they also can be covering remote employees. ADA accommodations. So again, that can be a little different for remote workers. That's something that employers need to work through with their own employment counsel. And then we're not going to be getting into, worker safety rules for each state or workers' compensation rules. And then international workers, we actually will touch on this just a little bit, I think, in the next section. But in general, when we're thinking about remote workers, we're really just talking about those remote workers in the US, even though I know our team does get questions sometimes about the applicability of some of these rules for international employees. And so if you are someone that has employees who want to work remotely outside of the US, that's when you want to make sure that you are working with employment counsel who is very familiar with international rules. Next slide, please. And so here are just some resources. Again, I don't want to leave you hanging on those topics, but if you do have a few employees in other states or you are considering allowing someone who's moving to still work, definitely want to make sure you are looking into, again, tax and labor laws for the various states and wage and hour laws. And so these IRS and Department of Labor websites are great catch-all resources because you can click on these links and then it'll actually give you the direct link to the respective states. And then the big disclaimer and kind of reminder here at the bottom, again, if you have remote workers in states that are outside of your home office or where you otherwise have an office presence, make sure you are working with employment counsel or some other similar service provider who can make sure that you are complying with these state laws. NFP does have a division, our Human Capital Solutions team. They may be able to help with some things related to, some state laws, policies, that kind of thing. So if that is something you are interested in, definitely reach out to your NFP consultant or account team member, and they can look into that for you. And now Yoko is going to kind of lead us through a basic overview of what you want to think about when it comes to remote workers.
Thank you, Kelly. So just to step back, when we talk about remote workers, so we reference remote workers as an employee who perform their job duties not in the your typical physical offices. However, they work, say, from home in different state or could be nearby your office, or could be work from WeWork or any coffee shop even. And I think we were all working remotely during the COVID time. And now that we're returning to work, but still more employees are remain to be working remotely. So this topic, this presentation is really addressing those remote workers and some challenges and some HR clients to think about, which is unique to the remote workers. And sometimes like hybrid workers or some employees return to work for return to office 3 times a week, but work from home twice a week. So those are mostly not addressed for special rules because they are primarily work in the office, but this is more for the entirely work remotely. And usually like carriers ask for employers to indicate like employer group size or any kind of employee demographics. And it's important to check with each carrier what each questionnaires indicate, and then that may impacts the insurance laws and other requirements. So, oops. And some challenges are as employees are more and more remote and then moving to like different states frequently, they may forget intentionally or unintentionally just not reporting to the HR or supervisor, and that will be maybe it's HR clients. Very very important to enforce the employees to notify you as an HR, because that will impact not just our employee benefits insurance, but also the state other employment state taxes and other areas as well. And make sure that generally speaking, remote workers should have a electronic device access. So it may not be so much of the issue, but you should be aware of the SPD electronic delivery safe harbor rules of, for example, not only to post on the internet, but also to notify the employee the importance of it and where to find it. So those extra steps need to be taken for especially for the remote workers. And for the international employees, some employees may voluntarily want to move outside of the US, but we work remotely. Those are different challenges. And that could be also employer request employee to work overseas as expats, or could be impat situations. So those are other big challenges for HR clients to think about. And the basic rule is if they're earning US source income, then you need to consider them as a full-time for the purposes of ACA employer mandate and a few other corporate other requirements. And so it's important to consult with your legal counsel, as international employees in particular are more complicated than the domestic employees, remote workers. Hand it back to Kelly to talk about the next topic.
All right, thanks, Yoko. So yeah, now we're gonna look at just kind of state insurance law rules in general and what employers need to be thinking about, again, as you're adding or if you already have those remote employees, because it can get confusing depending on funding type and some quirky state rules that exist. So to start us off, when do specific laws apply to benefit plans? So we start here with state health insurance mandates. And so these are things like coverage mandates that states have. So Illinois has fertility coverage requirements. That's an example of a coverage mandate. Some states are adding rules related to follow-up visits when someone has a mammogram, and then they have to go back for a follow-up from that. So different rules like that that are specific to that state. And so those coverage mandates apply to policies issued in those respective states. Think about that really as fully insured plans. So when I'm talking about policies issued, it's going to be a fully insured health plan there. Similarly, many COBRA laws, we're not going to really get into that today, but many COBRA laws are going to be based on where the health insurance policy is issued. Now, what's kind of interesting is that employers actually have some flexibility to choose the state that their policy is issued in. So if an employer, let's say, has locations in several states, depending on what the carrier allows, they can sometimes actually choose which state they want their policy to be issued out of, which then can tie back into these coverage mandates. And so an employer may choose a state that has, coverage mandates that they want to cover, or their employees are interested in, again, fertility being a very common one there. But again, you always have to check with the carrier on that. Generally, the carriers are going to require some level of employer presence in that state as opposed to just getting to pick whichever state. But definitely check with the carriers on that. It's also important to understand that, when a policy, so a fully insured health policy is issued in a state, typically then that policy does not have to comply with coverage mandates or state health insurance mandates from other states. So if my policy is issued here in Indiana, generally a fully insured plan is just going to be subject to any coverage mandates here in Indiana. However, you'll see the asterisk here, and we will get to that a little later. Self-insured plans. Okay, so a little bit different. Self-insured plans, typically, again, they're not going to be subject to those state health insurance mandates. So self-insured plans, and I'm also going to say level funded plans, right? Level funded plans really are self-insured plans. So if you sponsor a level funded plan, listen anytime we are talking about self-insured rules, because it is going to apply to you. So self-insured plans rely on what's called ERISA preemption. And so basically, ERISA is a federal law, and it actually preempts state laws in matters related to employee benefits. So when there's a conflict between the two, so what ERISA says and what a state law may say, ERISA is typically going to override that. And so that's why you might hear sometimes say, oh, ERISA preemption, generally we think of self-insured plans not having to deal with state insurance mandates because they are not subject to those rules. But we have the asterisk here too. And that is because this last bullet point here is some states have what we call extraterritorial mandates. And so extraterritorial mandates, and we'll get into this on the next slide, they're going to apply in those situations where we have that asterisk. So it's not quite as cut and dry, but we will get into that on this next slide here. So what are extraterritorial state health mandates? So these are situations where there's a state law, a state coverage mandate, and it is actually going to apply to fully insured coverage or fully insured health policies delivered to residents of the state. So these are situations where the policy is issued somewhere else, but if the policy covers a resident in one of those respective states, then that mandate is going to apply to them. So this can really be an issue when you have remote employees, because again, you may be familiar with the laws in the state, in which your policy is issued, but then you hire someone who lives in California, or, they were in your home state, but they move out there. Suddenly, you may actually be subject to some of these extraterritorial mandates. The insurance carriers are always going to be the best source of information to confirm any of these mandates that may apply to your policy. And that's because they, as the carrier, have to comply with these. So it's really important to check with them if you find out that you do have employees in other states. Like Yoko mentioned, making sure that you know where your employees are living is really important. And so we have just a brief example here of just some examples of extraterritorial mandates. Again, not an exhaustive list, not even an exhaustive list between, within these states, but just as ideas. So California requires coverage for domestic partners. So even if the policy is issued out of state, there are domestic partners that may need to be covered under a fully insured plan. Massachusetts requires coverage of ex-spouses. They also have some grandchildren mandates. So that could apply if you have someone residing in Massachusetts. And then Texas. Texas is what we think of as the most extraterritorial state. So it has a lot of mandates that it likes to apply to policies issued in other states. So Texas requires fully insured plans to cover unmarried grandchildren, has rules around coverage continuing through the end of the month of termination, and some things like that. So again, really just making sure that if you have employees outside of your home state, you need to understand when some of these extraterritorial rules may apply to your mandate or to your plan. And as I mentioned on the last slide, self-insured plans are not off the hook. Okay, so again, even though it's not fully insured and we think about ERISA preemption, there still can be some state laws that will apply to self-insured plans. And I've got a couple examples here too. So Hawaii, and we'll actually talk about Hawaii on the next slide too. Hawaii has the Prepaid Healthcare Act. It is applicable to both fully insured and self-insured plans, and it has specific health coverage requirements for employers and premium contribution limits, that kind of thing. Illinois has what's known as their Consumer Coverage Disclosure Act, or we call it, Essential Health Benefits Disclosure, which basically it requires plans to provide a disclosure that compares the plan's coverage to essential health benefits that are offered on the Illinois marketplace. And what's interesting, so here's an example. Illinois, this is written as a mandate for employers, not insurance carriers. And so that's why, because this law applies to employers, that's why it is applicable to both self-insured and fully insured plans. And I think this is one that kind of trips people up because, again, you assume, oh, I'm a self-insured plan or I'm in a different state, it doesn't apply. Well, right now, because it applies to employers, it would apply to a self-insured plan that covers someone in Illinois. And then New York, this is just kind of another one to think about. So New York has its Healthcare Reform Act, or HCRA. It's a surcharge for when someone receives care at specific facilities in New York. And there's a public goods pool that employers can participate in, or they can pay a surcharge directly. Again, not a mandate per se, but just something that is applicable to both fully insured and self-insured plans. And so, if you're an employer that has remote employees in New York, this may be something to consider a little bit more because you may be more likely to have people who are covered under your plan wanting to get care at those facilities. And then finally, here we have just a note that, many states have smoker protection or tobacco surcharge laws. And so some states will actually restrict an employer's ability to, charge more for smokers versus non-smokers. And those laws are typically written as state employment laws. And so that's why they can be applicable to self-insured plans because they're not insurance mandates. So we don't have a risk of preemption to rely on. It's actually a state employment law. Go ahead and go to the next slide. And I'm just going to walk through two quick examples here for just things to think about. Hawaii. I feel like we get asked Hawaii quite a bit. I think we're all dreaming of, fun in the sun. And so some employees are lucky enough to move there and enjoy it. And employers don't realize that Hawaii has some really unique laws. And so I mentioned before the Prepaid Healthcare Act. So employers have to offer approved coverage, which approved coverage is kind of a key definition here, to anyone working 20 hours or more per week. So, we think of the ACA employer mandate where that's mandating coverage at 30 hours. Well, Hawaii says their mandate applies at 20 hours. And I mentioned earlier, again, both fully insured and self-insured plans must comply. And so the health plan, this approved coverage, so it has to be approved by a Hawaii licensed carrier, or if you're offering a self-insured plan, it has to be approved by the state. Typically, an employer's regular offering is not sufficient. So typically, employers are going to have to look into Hawaii-specific plans if they do have employees who are working in Hawaii. Again, I mentioned there are contribution rules. So employers must contribute at least 50%, but here's the key. Employee contributions cannot be greater than 1.5% of wages. So that's pretty low. And so that's why it can get a little tricky here. You also can't have a longer waiting period. So coverage must begin after 4 consecutive work weeks, and then it must commence shortly thereafter. And then, say, oh, well, my employee, they're on their own individual plan. I don't need to do anything. That's not true. Individual coverage for just that employee is not going to be sufficient. And then Hawaii also has requirements for offering coverage for civil unions and domestic partners. And then Yoko will talk a little bit later about things like temporary disability, the TDI program under Hawaii. And we do have a screenshot here of our Hawaii benefit considerations publication. So if you do have employees in Hawaii, make sure to request a copy of that because it's got a lot of helpful information. And then another example here, California. I think most people in the benefit space understand that if you have employees in California, there are definitely a lot of rules to consider both on the benefit side and then obviously on the employment law side too. And so again, domestic partners who live in California, so even if the policy is issued in a different state, they need to cover domestic partners. There are some unique notices that are required for both FSAs and then the California HIP program for employees who are terminating. Again, they have statutory disability and paid family leave we'll talk about later. California has a lot of different leave requirements related to pregnancy and disability, the Family Rights Act, again, California paid sick leave. So lots of things to think about there. And then even further, there are cities and counties that have some of their own requirements as well. So sick leave ordinances, commuter benefits, pulled out the example here, the San Francisco Healthcare Security Ordinance, which many may be familiar with. So a lot of things. So again, that's why it's so important to engage employment counsel if you do have someone, because again, even just one employee or a handful of employees in a state like California can really add a lot of extra work to your plate. And again, we've got a publication and toolkit for California as well, so definitely request a copy of that if you need it. All right, now Yoko is going to take us through FMLA and state leave laws.
Great, thank you, Kelly. So for this section, we're gonna talk about the leave as a main topic, and that will be addressing the federal level FMLA as well as the state PFML. It's also called disability insurance paid family leave, and also state version of FMLA, and how that will be that will impact you as an HR client if you have a lot of remote workers or employees in multiple states, and some tips to consider as well. And the first two slides, we're gonna go over some big picture of what are the steps that you should take, which you may already be taking, but this might be your review. But first step is to look at the employee's work allocation. And then to see which federal and state leave laws will apply to your remote workers, as well as those employees who work in your physical office as well. And FMLA, whether that will apply to specific employee in like one employee in Ohio versus other employees are in different states, for example, that 75 miles, whether applies or not, we're gonna go over that. And whether even if your group size is below 50, there might be a possibility of state version of FMLA that provides similar entitlement may apply. And then more up and coming, more important requirement for you to consider is a state paid family medical leave. And it is also called disability insurance and paid family leave. But and also state and city paid sick leave or other form of like shorter, much shorter duration of paid time off requirements. We're not gonna go into detail, but we will touch on it briefly on that topic. And second thing to consider is that now we know you know which laws to consider will be applied to your remote worker and your in-office employees. Next thing to think about is what type of leave policy that you already have in place, and how would that your employer provided benefits will coordinate with the mandatory federal and state laws. For example, you may already provide employee who are pregnant for pregnancy-related disability leave. And you may also provide bonding leave, also called parental leave, for both male and female employees. Or you may also provide caregiver leave for employees to take time off to care for a seriously ill family member, or could be grandparents or parents, depending on your definition. And you may already have STD, short-term disability, and or long-term disability, and that provide the partial wage replacement in case an employee becomes disabled or seriously ill, so they have to take time off, partial or fully, from work for a certain period of time. That's the income replacement. And next thing to consider, I'm sorry, is that which law or which your employer policy requires maintaining group health plan. That this question comes up pretty often for us from our employer clients, whether in the form of do we need to continue the group health plan, or should we discontinue because it's not required and COBRA should be offered? Or I want to be more generous beyond FMLA or protected leave. What can we do? What's allowed? So those are the questions we often get. And important things to consider is that, so to consider the difference between the protected leave, which is the federal and state FMLA, and some PFML requires a continuation of group health plan during the approved leave. So those are requirements that you need to continue the group health plan in the same condition that they had prior to leave, or they would have given if they were not on the leave. So they'll get the similar same open enrollment election period if it's the timing, if they are still on the leave, and other employee rights and protection as well. But some employees want to continue or intentionally and unintentionally provide longer continuation of benefits beyond what's protected. So beyond like 12 weeks of FMLA. And if that's the case, it's very important for the employer to get the approval in advance from the carriers or stop loss carriers, depending on the fully insured or self-insured, whether they will approve whether you can continue the coverage or not. Otherwise, they may not allow coverage for the insurance. They ended up being you may be insuring those extended coverage. And also then another important thing is while they're on the leave, how to collect the employee share of contribution. Those all the nitty-gritty important details should be already determined in advance. It should be written in your leave policy and communicated with employees. And the fourth is another component to think about in addition to the traditional, like not traditional, but existing FMLA and a PFML law is that if you are subject to ACA employer mandate, because you have at least 50 employees or more on a control group basis, you're subject to employer mandate, then if you use a look back measurement method instead of the monthly method, then you need to consider the consequence of employees on the leave and the stability period, assuming that if they have worked at least 30 hours per week in the prior preceding like measurement period, then you need to continue, generally speaking, you need to continue the coverage until the stability period. So for the medical coverage. So there are quite a few things to kind of coordinate and think about in terms of the maintaining group health plan while employees on the leave in general, and especially for the remote employees as well. So the first one to just focus on is the FMLA refresher. So which employees are eligible for FMLA? And for the employer side, for the covered employers is a private sector employer with at least 50 employees in 20 or more work week in the current calendar year or previous calendar year, and all the public agencies, regardless of the employee number, and local educational agencies are subject to FMLA, so they're considered covered employers. And so if so, then you have to also are subject to all those poster and notice requirements automatically. And now which employees are eligible for FMLA? So generally speaking, those employees who work for a covered employer for at least 12 months and have at least 1,250 hours of service during that 12 months before their leave starts, and work at a location where the employer has at least 50 employees within 75 miles. And the tricky part about the remote worker is that definition of FMLA for remote workers is not based on the employee's personal residence, but it's based on the work site. So it's based on where employee report to, or the office that they get the assignments are made. So even if you have you have like total 100 employees, you're covered employer, but you have 1 or 2 employees scattered across the different states, like one employee in Kansas, maybe another employee in Oregon. And even if those employees are one employee in each state, if they report to you as a headquarters, say in New York, then they're considered covered employees and they're eligible to take FMLA. And then if that's the case, then another requirement, as mentioned, is a covered employer needs to post I put the screenshot there, the poster, and keep posted. And as it's updated, sometimes in every few years they update it, so post the updated version at all times. And for those employees who work in your physical office, it's easier to just display the poster, and many employers just contract it out to the vendor to just put the mandatory poster in your workplace. But the challenge is for the remote worker, excuse me. And then for those remote workers, you're required to send this poster electronically. And assuming that, make sure that they have access to electronic mode. And then if you decide to post in your intranet or server or wherever you decide to, that's where you usually post your employee communication. Make sure the employee remote worker has access to it easily at any time. And then communicate with the employee that the FMLA poster was posted and where they can find it. So that will satisfy the notice poster requirement. And as you know that there are quite a few other, this is general notice, but there are quite a few other notices requirement associated with the FMLA, say rights and eligibility notice and designation notice. So those also, all the same notice requirements apply to the remote workers. So you need to make sure to send it electronically and then ideally to get the proof of receipt if possible and document when it was sent. And then changing the subject from FMLA. So maintenance and group health plan during the leaves. So what's required, as mentioned, is FMLA, some PFML program, and ACA employer mandate provision require employer to continue the group health plans during leave. For FMLA and some PFML requires employer to continue medical, dental, vision, and those basic core, and an employer mandate requires the employer to continue medical coverage during that specified period. And so it's because each state has a different rules. Some PFML do not require the requirement, but it usually runs concurrently with the FMLA. So FMLA requires employer to continue the group health plan anyway. But some PFML that is not covered by FMLA will require certain, not everything, but some PFML require employee to continue the group health plan. So you need to consider where employee works and whether that employee is eligible for both or either FMLA or PFML, and then consider whether continue the coverage is required. And similarly for the employer mandate, as mentioned, if you use a look back measurement, then you need to consider whether you need to continue the coverage until the end of the current stability period, except for certain exception there. And if you decide outside of the requirement, if you decide to continue the coverage voluntarily because you want to be more generous, you want to be supportive, then it's very important to get the approval in advance from the carrier, respective carrier for depending on which coverage you want to continue, for full insured plans and stop loss carrier for self-insured plans. And make sure that your plan document, once it's approved and you want to put in your place, then it makes sure that your plan document and leave policy were updated to reflect that continuation of coverage for the extended period. And keep in mind that once you provide the exception, you're creating a precedent. So even though you want to be very, very helpful and generous to one employee, that may create a precedent, and the other employee may request a similar accommodation request for extension of coverage. So something to keep in mind. So the best practice is to offer the exact same extension of coverage with a similar condition to all other similar situated employees. And COBRA implication here is assuming that you are subject to COBRA, then when the coverage is discontinued because either the employee is not eligible for neither FMLA or PFML and 9 a look back, then COBRA needs to be offered. So whenever the benefit coverage is lost, according to the plan document, then a COBRA needs to be triggered on offer and reinstated when the employees return from the leave. And I've been mentioning about PFML, and here is the right side of the green box is a list of currently a list of states that currently enacted the requirement for either disability insurance only or both disability insurance and paid family leave. So you can kind of see how long the list is getting more and more each year. And very few states, 2 states are optional, but all other states are mandated. So it's required, it's important for client for you to make sure that you know, just to check through if you have any employees who are working any of the state. Even one employee in, say, Colorado or Maine will trigger you to be a covered employer. And then the general thumbs rule is that where employee works, it matters instead of where employee reside. And then except for the Delaware, most of the other states will trigger the requirement for you as an employer, even if you have only one employee in that state. And you have a couple options to comply with the state PFML. Many employers choose to do the big state-based program, but some employers chooses to elect private plan in lieu of the state-based program. Generally, like purchase from your own STD carrier, so that STD and then the PFML is benefits the tracking the leave is more coordinated and a better employee relation. So it depends on pros and cons. Depending on the preference of the employer, here are the options. And what employers need to do in order to comply with the PFML is that, as mentioned, review the employee's main work states. And so which state PFML is apply for your company, and decide whether to participate in state-based versus the private plan. And just to highlight, there's no private plan that applies for all state PFML. You need to get the approval and purchase a specific private plan for each state PFML. And once you do that, especially for the state, you have to register with the respective PFML program and collect the premium of their share and remit the premium along with the reporting to the state, generally quarterly basis. And then comply with all the required notices and poster. Some states require annual notices, some states just maybe once in a few years. So depending on the state PFML. And it's important to coordinate PFML. Make sure the FMLA is designated when it's a shared qualified reason, say employee's own disability or pregnancy disability or bonding. Make sure the FMLA is designated and run concurrently with the PFML. And importantly, it's important to have a comprehensive written leave policy and communicate that leave policy with the employees. And I'll go over very quickly. So this is a slightly out of our scope, but other leave policy, the leave consideration is the paid sick leave and other much shorter time paid time off that are required by certain states or the county or the city. So here's the list. So those are separate from the PFML. PFML more of the insurance, but this is more of the transacted part of your PTO, sick days or vacation, or more of the PTO process. And we would strongly recommend you to consult with your HR advisor or any employment counsel to make sure that you're in compliance with all the applicable state and county or city requirement for the short-term leave paid time off policy. Okay, now I hand it back to Kelly.
All right, thanks, Yoko. Yeah, the information on FMLA I know can be really confusing with remote employees. We had some good questions in there. And then, yeah, making sure that you are working with your employment counsel, like Yoko said, because you want to make sure that you are complying with those state PFML programs. Any of those shorter term sick leave laws that she mentioned are really important. And so now we're going to take a dive into state individual mandate reporting requirements. Again, this is only going to be applicable to some groups, so we'll kind of hit it at a high level. But I mentioned at the beginning, again, I think we're all really familiar with the fact that We have the federal ACA employer mandate recording requirements. Those lovely 1095C forms that I think a lot of you are familiar with. So that requirement applies to employers with 50 or more full-time equivalents in the prior calendar year. However, we have 6 states that also have their own individual mandate reporting requirements. And so for the states, it's a little different. This actually applies to employers of all sizes. So not just the federal, 50 or more employees, but smaller employers, this can apply to them as well. And so these reporting requirements are going to be based on an employee's home address. So not where the employer is located, but the home address. So again, that's why it's important for remote employees, because if you have remote employees in one of these states listed here, you may have additional reporting requirements that you need to make sure are being handled. And so we have a note here at the bottom. I think it's really important. So we recently had President Biden signed the Paperwork Burden Reduction Act, which basically gives employers the option to provide the Form 1095-C only upon request. So instead of automatically, it getting sent out every January or by every March, employers will have the option to just allow employees to request it. Kind of the key part here is that employers have to give employees notice of this option. And right now, because this was just signed, we don't have guidance from the IRS on any specific notice requirements. So really the conservative approach for Form 1095-C on the federal level is to sort of business as usual, at least for this next year. And that has an important implication here on this state individual reporting, because these states listed here, they have requirements to distribute those forms to employees. And so if you're not distributing it to your employees because of this new federal rule, you still probably have to for these various states. So we'll go ahead and we'll take just a quick look at some of the states here and what those requirements are. So again, I mentioned that there were 6 states, so California is one of them. The big thing to note here at the top, so if an employer has at least one employee, spouse, or dependent who is enrolled in the medical plan and resides in California, there is a reporting requirement. And so again, you have one remote employee who is in California. You're going to have these extra steps to take that you may not have been aware of. Now, the good news is fully insured plans, the carriers are handling it, but for these state things, we always recommend confirming with them. Self-insured plans, the employer has to do it. So again, using that form 1095B or C. So that's why it's important that those are still being put together and distributed. So the forms have to be distributed for California by January 31st. So again, the note here, nothing has changed with this deadline, even though we have, the law that President Biden signed. So if you have California employees, make sure that you are working on getting those forms distributed to residents by January 31st. And then, of course, there's a filing to the state due by March 31st, although you actually have until the end of May to file those and avoid penalties. All right, next slide, please. So DC, again, very similar. They do it a little bit differently. For self-insured, it's the same in the sense that if an employer has at least one employee who's enrolled in the medical plan that resides in DC and it is a self-insured plan, they have a reporting requirement. Now, for fully insured plans, it's a little different. Fully insured, it's only going to be if they're subject to the federal mandate, so 50 full-time equivalents, and at least one of those employees resides in DC. Again, once again, they have to distribute the federal forms. So nothing's going to change with needing to do that currently. And then they have to file with the state as well. And this one's due by March 31st, same rules as before. Thus far, nothing has changed even with the new law. Next one, please. Massachusetts, Again, so one employee, spouse, or dependent enrolled in the medical plan who resides in Massachusetts. So kind of the same criteria that we saw with California. Now, Massachusetts is a little different because they actually have their own form. So they have the MA 1099HC. And so that is because Massachusetts has actually had their own individual mandate for a long time. And so they have their own form there. And again, carriers for fully insured plans, they are likely handling it, but it's always good to confirm. Again, especially if your policy is issued outside of Massachusetts and you just happen to have, one or a handful of employees who are in Massachusetts. You want to make sure that that state reporting is being handled by whichever vendor you use for your federal 1095s. Again, those are due by the end of January, just like California. And thus far, those rules have not changed. So make sure that that is getting taken care of soon. Next one, please. New Jersey, again, you have one employee enrolled in the medical plan who resides in New Jersey. You have a requirement here. And we've got a little bit of a breakdown here as far as depending on employer size, as far as, again, what form needs to be used, but generally it's still going to be those federal 1095, either B or C. If you're fully insured, make sure that the carrier is handling it. These are going to follow federal distribution rules, so distribution by March 3rd and then filing by the end of March. Next one, please. Rhode Island, again, one employee enrolled in medical plan who's residing in Rhode Island. They also will trigger reporting requirements. Again, complying with the federal mandate and those timelines. Rhode Island's going to follow that same cadence there. Again, if your carrier is handling it, go ahead and double check with them. If you are that fully insured plan, if you are a self-insured plan, the employer is going to have that obligation to file. Next one, please. And then Vermont. So Vermont's on the list because they technically have an individual mandate that says, residents have to have minimum essential coverage. Right now, there's no enforcement of the mandate and there are no penalties. So right now we don't have an employer reporting requirement, but we just list it here because technically they do have a mandate in place. So we could see reporting obligations in the future. Next slide, please. And we do have a great publication and toolkit on this. So if you have employees in these 6 states that we mentioned, this is a great resource to request from your consultant or your account team because it's going to kind of break down the information that we just talked through at a very high level. And then Yoko is going to take us away with takeaways and resources to kind of close us out.
Thank you, Kelly. So as you might have noticed, depending on the law and the requirement, the applicability of which law or which requirement applies to your remote workers are different. Say, like the Kelly mentioned about the state individual mandate applies on the resident basis versus the PFML applies on the work location. And insurance mandates law that you generally apply for the fully insured plans are mainly site as location, except for the other exception that Kelly mentioned about. So it's very important to kind of overall review which laws will apply to which employees. Unfortunately, it's not a straightforward analysis, but it's worthwhile taking time. So first step for fully insured and self-insured is to identify locations of workers who are working remotely outside of your employer state and physical offices, and make sure that you're in compliant with all other requirements that may apply to those remote workers as well as those in the physical offices. And when you communicate with the insurance carriers, make sure to include those remote workers in the intake form or any other communication that they are aware. And then the individual mandate and other requirement needs to be really met, regardless of where they are. Importantly, based on where they are, and that would trigger the applicability. And it's very important for you to, as you can see, the complexity and the variance depending on the law. So it's very important for you to engage with employment legal counsel, HR advisor. As Kelly mentioned, we have a HR team that may be helpful for you with the consultation fee. And Kelly, anything to add before move on to the resources?
Nope, I think you've got it.
Okay, great. And here is a list of publications that we have. So as the prior slide said, as much as it seems overwhelming, we are here for you to support and assist. And here are the resources, publications to navigate through and then help you deepen your understanding of each requirement. And a quick reference chart might be a good helpful one for the PFML, and other state-based one is helpful to understand what are the overall requirements apply for your remote workers. And hand it back to you, Kelly.
All right, thanks, Yoko. Yeah, we like listing out all those publications because, we both mentioned a lot of helpful ones here. So definitely request a copy of those. If we talked about a state or, a leave requirement that you are interested in, because yeah, it is really hard to keep track of all this when you just have 1 or 2 employees in some of these states that have some really tricky laws. So definitely check with your consultant or account team to see if we have something that might be available. And then again, definitely make sure that you are consulting with employment counsel, because handling those requirements with remote employees is, much further reaching than just benefits. You want to make sure that you are getting the personnel and employment law side and wage and hour stuff covered as well. But yeah, so I hope you all enjoyed this and learned a few things. And we appreciate you joining us for this today. And I will let Amber close us out.
All right. Thank you, Kelly. And Yoko as well for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We will be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday you'll receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey, as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you everyone for joining us, and have a great day.